She sat in that courtroom while his attorney called her the one who quit, who walked away from a devoted family man after 12 years together. And technically, those facts were accurate. She had filed. She had left the marital home. She was, by the most surface-level reading of the record, the one who chose to end things. What his legal team could not have anticipated was what she had been quietly documenting for over a decade. When her attorney began reading it aloud, the definition of fighting for your family was about to get very complicated. Here's the full story. 12 years, 2 children, a mortgage, school pickups, dance recitals, youth sports. From the outside, this looked exactly like a functioning family, 2 people who had chosen each other and built something real. He was a provider, steady income, present in the home, financially reliable. She was the emotional anchor. Their marriage had all the outward markers of a couple who meant it. Paper doesn't tell the whole story. It never does. We'll refer to them as Sarah and David, not their real names, but real people with real children caught in the middle of what became one of the most emotionally layered divorce cases I've encountered. David was, by every outward measure, a family man. He showed up. He paid the bills. He stayed in the house. When the case reached family court, his attorney led with exactly that. David never left. David always fought for his family. What his legal team hadn't fully accounted for was that Sarah had spent years keeping records, and her attorney was about to use all of them. Sarah had filed for divorce. She was the initiating party. She left the marital home. In family court, those facts carry real weight. The spouse who files first, who vacates the residence first, can find themselves inside an unfair narrative before the first witness is ever called. David's team understood this dynamic and used it effectively. What they couldn't neutralize was the documentation on the other side. Years of it, methodically preserved. Let's hear David's side first. Intellectual honesty demands it. His argument was not baseless. He was physically present throughout the marriage. Every time there was a rupture, he came back. He paid the mortgage. He funded the kids' extracurriculars, the school supplies, the routines that hold a family together. By his own account, he never abandoned his family. He stayed. He provided. He was there. That was his position, and parts of it were true. And there is an uncomfortable truth buried in that argument. Some couples do survive infidelity, emerging from betrayal with renewed commitment, better communication, a kind of scar tissue that holds. Reconciliation is real. It happens. The question this court was being asked wasn't whether David believed he was fighting for his family. It was who was actually bearing the cost of that fight, and for how long, and whether any of it had been agreed to. Now the story pivots completely, because Sarah wasn't processing one affair and choosing to forgive. The first documented incident came while she was pregnant with their second child. He was involved with a coworker. One night she couldn't locate him. She drove to a woman's house while pregnant because something didn't add up. His motorcycle was in the driveway. She knocked. No one answered, so she let herself in. What she found in the bedroom was not a misunderstanding. That was not the end. That was the pattern establishing itself. Another coworker he admitted feelings for, then spent a week living with her. Text messages he sent Sarah linking to the state-mandated divorce education courses while they were still married. Women's underwear found in his car. Explicit conversations discovered on his phone. An au pair, someone hired to come into their home to care for their children, who he had also been involved with. A trip abroad. A sworn promise made. He promised he wasn't going to see a woman named Angelica on that overseas trip. He lied. Confronted afterward, he proposed something extraordinary, maintaining a part-time home in another country to divide his time between his family and her. Not ending the marriage, just expanding it in one direction, with Sarah as the fixed anchor of the other. She would later describe herself as a luxury car kept under a cover in the garage while he drove newer models around town. What would you do if your spouse made that proposal? Here is the legal context you need before we go further. In most U.S. states, divorce is now no fault, meaning either spouse can file without proving the other did anything wrong. That's a relatively modern development designed to reduce adversarial proceedings and protect people trapped in destructive marriages. But no-fault filing does not make marital misconduct disappear from the room. In states that allow it, documented infidelity can directly influence alimony awards and the division of property. It doesn't vanish. It arrives through a different door. There's also a legal doctrine called dissipation of marital assets. When a spouse uses shared funds, money that legally belongs to both parties, to finance a relationship outside the marriage, those expenditures become relevant to property division. hotels, flights, gifts, a proposed part-time home abroad. Every dollar spent outside the marriage was, technically, a dollar extracted from the marital estate. Sarah's attorneys were building a picture, transaction by transaction. In family court, the receipts don't lie. One more concept worth knowing: constructive abandonment. Unlike physically leaving the home, constructive abandonment is the willful, sustained withdrawal from the obligations of a marriage. Several states recognize that a spouse who serially betrays the marital contract has, in a meaningful legal sense, abandoned that marriage, regardless of whose name is on the lease. Sarah hadn't walked out on the marriage. The marriage had been systematically dismantled around her, one incident at a time. When proceedings formally began, David's legal team moved quickly to establish their narrative. Sarah had filed. Sarah had left the home. Sarah was, by the most surface-level reading of the facts, the one who chose to end the marriage. They pressed this framing consistently and effectively. What they hadn't fully prepared for was the scope of what Sarah's attorney had compiled and what it would look like presented chronologically, exhibit by exhibit, in front of a family court judge. The documentation spanned the entirety of the marriage. Text records, travel logs, the conversation in which David admitted the lie about Angelica and then admitted what he wanted from the situation going forward. Financial records showing marital funds spent in ways inconsistent with household expenses. Records tied to the au pair's employment period. What had been Sarah's private archive of humiliation became, in that courtroom, a formal exhibit. Years of silently absorbing transformed, finally, into testimony. At some point in the proceedings, David's team had to shift posture. You can only argue devoted family man for so long when opposing counsel is reading documented incidents aloud in chronological order. What came next was a different argument. That Sarah had known about some of the conduct and had eventually agreed to an open arrangement where both parties dated others. This is where the case became genuinely complicated, because that part was also true. After years of absorbing betrayal and taking David back, Sarah had reached a threshold, not a decision to leave, but a decision to stop pretending. She eventually agreed to an open relationship. Both parties dated others. Sarah's attorney was fully prepared for this argument, because there is a critical legal and moral distinction between an open arrangement entered freely, with genuine mutual consent, and a decade of prior deception that had forced the question in the first place. Consent obtained through exhaustion is not freely given consent. There is a moment in every family court case where the emotional reality of a situation collides with the legal structure trying to contain it. This was that moment. Sarah sat in that room, and for the first time in 12 years, was not the one explaining away the unexplainable. She was not softening the edges of a story that didn't deserve soft edges. She was telling the truth, all of it. What would you do with that floor after years of staying quiet? The judge did not rule in a vacuum. Family court judges are trained to cut through competing narratives and evaluate documented behavior over time. What this court found was unambiguous. Sarah had not abandoned her marriage. She had stayed, repeatedly, at significant personal cost. Each time she took David back, she was not surrendering. She was absorbing damage in the hope that something would finally change. The decision to file was not, in the court's assessment, abandonment. It was a reasonable response to a documented, sustained pattern. The financial settlement reflected those findings. Asset division was structured to account for the years Sarah had anchored the family largely without reciprocal support, and for the documented dissipation of marital funds across the course of the marriage. Alimony was awarded. The dissipation argument held. David's legal team had argued for equal distribution. The court found that the circumstances and the conduct had not been equal. Custody arrangements were built around the children's established patterns. The extracurriculars, the schooling, the daily routines Sarah had maintained consistently throughout the marriage. David was not denied access to his children. The court acknowledged his role as a father. What it also noted, with particular attention from the bench, was the pattern of introducing the family's household to a series of outside relationships, including the au pair situation, which proved difficult for his team to adequately address. Here is what a ruling like this does and does not do. It draws a legal line. It establishes on paper what the court determined to be fair. What it cannot do is return 12 years. It cannot give back the nights Sarah drove through neighborhoods looking for her husband. It cannot restore the version of herself she quietly lost somewhere in the middle of a marriage she was determined to save. A judge's signature ends a case. It does not end the aftermath. Healing operates in a separate jurisdiction entirely. In the time since the ruling, Sarah rebuilt, slowly, imperfectly, without a roadmap. She was the first to admit she didn't pull herself up by her bootstraps. She stumbled through it, cried through it, made every mistake available to someone starting over with 2 children and a fractured sense of identity. That process, the rebuilding after the ruling, never appears in the legal record. But it is, by a wide margin, the most important chapter of any family court story. David remarried, his children attended, and Sarah, publicly, genuinely, said she hoped he treated his new wife well, that their kids would see a healthy relationship modeled for them. That's not the statement of someone who lost. That's the statement of someone who finally found solid ground. Her new life, she said, is humble, but it's hers. After 12 years of living inside a story that was never really hers to write, that single word carries more weight than any court order could. If this case raised questions for you about how courts weigh years of documented infidelity, what no-fault divorce actually means in practice, or how dissipation of marital assets factors into a financial settlement, we have a full legal breakdown linked in the description below. And I want to hear from you. Have you witnessed a case like this one? Have you stayed in a situation when leaving would have been the easier path? Tell me in the comments. And if you want to see what happens when the evidence tells a very different story than the official narrative, that case is already queued up next.